Hey guys, pretty big update on the Kaceytron or Ethan Klein versus Kaceytron. It looks like it's getting one step closer to settlement. They have designated a neutral. I've done some research on this neutral, this mediator, and he is well. And I'll have screenshots not of his name, but of his accomplishment. This is somebody who is very famous in Missouri. This is someone who is quite accomplished. He actually went to Harvard for undergrad and Georgetown, which is a top 14. So if you've ever gone to law school, you know that there's top 14, top 30, top 50, top 100. And that is how you apply to law school. So this guy is a very, very good lawyer who is the mediator of this case. Hopefully, he can reach a settlement. I really don't think Kaceytron is taking it all that well. She is very emotional and therefore has had many emotional breakdowns. So the neutral's name has been decided. The session or mediation has been decided for December 1st. There won't be much to update. It's almost like CoffeeZilla. Once we get to this stage, there's very, very little updates further. So they will mediate. It will be either by virtual. So the mediator is in Missouri. The mediator is in the state Kaceytron lives in. And I believe the mediator has been probably used by the court. Remember, the court that Ethan had to sue in because Kaceytron is a citizen of Missouri is Missouri. So the mediator they're using that they have agreed upon is somebody who's relatively known here. So what is mediation in terms of a copyright lawsuit? Mediation in a copyright lawsuit is a way to settle. It is a way to settle without going to trial with the help of a neutral third party called a mediator. Often it is very informal, it's private, it's cheaper than going to court. It's cheaper than this is the way to do it. I've done mediation many times. Court will force mediation. Like I said, they do not want to deal. If you, the plaintiff and defendant, can come to a agreement, there's no way that the agreement gets overturned on appeal because there's nothing to overturn. It's just almost contract. It's a contract between plaintiff and defendant agreeing on certain terms. And the court does have to approve it, but it would be very rare for it to not approve. For it not to approve a agreement during mediation would be, it would have to think that some type of abuse was being done, and it would have to be very severe abuse. But again, like this lawyer who is heading the mediation, everything I've learned about him is he's really fair, really smart, and that's all you can really ask for. So what are these steps? So mediation is a part of alternative dispute resolution, ADR, a process used to resolve disputes outside the court. It is voluntary in most federal copyright cases, but some courts like California require the parties to at least attempt mediation or another form of ADR. So attempt doesn't mean you actually do mediation. Attempt is just like, oh, well, we tried to do it, but nobody was interested, or one of the parties is not interested. So the mediator doesn't decide who's right or wrong. This is very important to understand. A mediator is not a judge. Okay, a mediator is not going to give their opinion that you are wrong, you're right. The mediator is only there to help people talk, negotiate, and reach a settlement. So they are a neutral third party. They're not there to put blame on anyone. They're not there to say, oh, Kaceytron, you clearly committed copyright. There's going to be no talks about that. They just want to know, Ethan, what is your best outcome? Do you have a range of outcomes that would be acceptable to you? Kaceytron, what is your best outcome? And do you have a range of outcomes that will be acceptable to you? And then they take the look at the two ranges and see if something can be proposed. And mediators do a really good job because none of what you're talking about will ever make it publicly. This is very different from a trial or a lawsuit where every document is going to be on Court Listener, Westlaw, or LexisNexis, right? And it's going to be chronological, which I like. No, this is more or less a private discussion where you have somebody who is respected member of the law community, right, and has a good reputation with the court, And he'll basically tell you how things are. So when we did our mediation, our mediator was the previous judge, the current judge of our case replaced. So that he has a lot of weight, right? Because he can predict how things are going to go for either side. He can predict and give us the ranges. So there are actually three ranges at play. There's the range of my outcome that I want. There's a range of the opposing party's outcome that I want. And there's the range that the judge believes if this were to go to trial, you would have to pay out or you would have to get paid, like, like the damages. So who is the mediator? The mediator is neutral. He is not on either side. Both sides agree that this individual is neutral, and there's no takesy backsies, right? Once you agree to a mediator, that's who you agree to. Often a lawyer, in this case it is a lawyer, or retired judge with experience in copyright or intellectual property. Let me read you a little bit of profile from this guy. Intellectual property litigation, counseling, and mediation services nationwide, admitted in New York, Missouri, and the United States Patent and Trademark Office, and the United States Court of Appeal for the federal 6th, 10th, and 11th circuits. Specialties: Hatch-Waxman, pharmaceutical, biotech, medical device, and industrial chemical patent litigation. He's a patent attorney. You know how I feel about patent attorneys. We are the top of the top when it comes to IP. Also, counseling, portfolio strategies, and diligence analysis for corporate and investment fund clients. It goes on for a little bit of time. He graduated Georgetown Law in 1993, so this is a older gentleman. He graduated Harvard University in 1989, and he was part of the Harvard Bridge Club. Okay, good to know. So basically, this is a very well-respected person in Missouri whose only goal is to try to avoid you going to trial, and they are going to be very okay. So when does mediation happen? It happens early in the case, before discovery. So before discovery, you're trying to say, okay, but before we start digging, is there an outcome Ethan Klein is happy with that would also make Kaceytron happy, or at the very least, not happy? Both parties are not going to go home happy, but you could live with the outcome. So it could be early in the case, before discovery. That's where it is right now. It could be after discovery, once both sides know the evidence, and then they can decide how strong their cases are. This mediation seems to be before discovery, which would mean it is much more likely to settle at that point in time, because when you put more money into the furnace that is your legal billing, the more you pay your lawyer, the less likely you are going to settle, because the more you have invested. It's the whole sunken fallacy idea, right? Or even right before trial. So our mediation happened after discovery, and at that point, I think it was already too late. We all just want to go to trial. So even though the mediator was a very, very outstanding judge and had a lot of sway, he couldn't get us to settle or resolve our issues until we went right before trial. So what happens during mediation? There's an opening session. The mediator explains the rules. Each side gives a short summary of their views of the case, what happened, what they want, and why. Now, there are private sessions. These are called caucuses in legal terminology. The mediator meets privately with each side to discuss their case, strengths and weaknesses, and settlement goals. The mediator may carry offers and counter offers back and forth. Negotiation. The parties explore possible settlements, such as paying a licensing fee, taking down the infringing work, agreeing on a confidentiality clause or apology, or a combination of money and corrective actions. Resolution. If both sides agree, the mediator helps draft a written settlement agreement. If not, the case goes back to court, but discussions stay confidential. That's really important to know. Discussions will be confidential. So let me know if you guys want to learn more about mediation. Most cases are solved by mediation, surprisingly, I know. Anyway, let me know in the comments below. Bye, guys.